conference on Monday. My understanding that we are ready to proceed. But that said, let me go ahead and get the official announcement from the secretary.
The stage is ready, Your Honor.
We're ready on behalf of Travis and Michael.
Ready on behalf of Greg.
Same with Mr. Bryan.
The matters before the court then are motions for new trial filed by all three defendants. There may be some preliminary matters we need to address, so let's go ahead and see what's there. So, anyone take one?
Not at this time, Your Honor.
On behalf of Travis and Michael.
Your Honor, based on, I don't move real quickly. Based on our conversation, I think my understanding is that we need to do something with regard to a proffer and a juror testimony, and there are issues there that I suppose we need to take up before we get into anything else. Well, and the state is taking position that we need to have some preliminary consideration by the court as to whether that testimony will be permitted. And that's, it seems to me that that needs to be early in our activities today.
Check. Your Honor, we joined with Travis and Michael in the motion trial. Same issue, yes, sir. All right, Mr. Johnson.
I want to be back out, so we'll be next week.
All right, so why don't we go ahead and address what we have. When I say what we have, what I understand the issue to be before the court. That are getting the posted going to trial. The lawyers come to check the gallery to ensure that there are no witnesses in the gallery who they would expect to call, and then continue to check the gallery to ensure.
I don't know whether we have two jurors who have been subpoenaed and are here. One who's been very reluctant to come, and I told her that I would put her on a 1 hour notice rather than make it's an unusual inconvenience for her. So we'll call her on an hour notice. And if juror 79 and juror 380 are here.
Perhaps, Your Honor, if we could just announce, is anybody here?
Understands they are under subpoena and being asked to testify in today's proceeding. Please take a step outside and wait there until you are called. Your Honor, can we invoke an exception for the investigator of the case? You can tell preparation of trial.
As the state often does.
Mr. Wilson is our investigator, and he will be testifying, and he will be testifying early on. But typically, investigation permits.
Let's do this. During this preliminary portion, since we are addressing witnesses' testimony, I'm going to ask that you step outside. Let's take this matter up after the preliminary matters have been addressed.
He will be the first witness on the issue that we're addressing, but I don't even know if the court wants to hear the witnesses yet. So, anyway.
Thank you, Your Honor. Your Honor, in this particular case, Travis McMichael and Greg McMichael filed their amended motion. They had previously filed a preliminary motion for new trial back in May, and Mr. Bryan had filed his motion for new trial, his amended motion for new trial back in May 2024. At that time, they brought up the issue to the state and this court that their investigator, Lee Wilson, had attempted to approach all 12 jurors in this case to interview them. 9 refused, 3 agreed, and spoke with Mr. Wilson. The state's, of course, first concern with that is that in approaching these 3 jurors, Mr. Wilson lied to them. He said he was there to interview them to find out what the trial teams had done wrong or could do better in the future. He also told them that it was a confidential interview. He recorded them without informing them, which is legal in the state of Georgia. But he then proceeded to ask them a series of questions designed not to find out what the trial teams had actually done, but to procure evidence in a state's position in a legal attempt to violate Rule 606 and impeach this verdict. So the state has a deep concern about how these interviews were conducted and how this testimony was elicited. And the basis for our objection is actually the United States Supreme Court. The United States Supreme Court has basically held that the substance of Rule 606, which has not changed since 1975 when it was enacted, with one exception in 2006 where it modified permitting evidence for the clerical mistake on the verdict form. Our Rule 606, which was enacted in our new evidence code in 2013, is identical to that particular 2006 Rule 606 federally. But in 2017, in Pena Rodriguez versus Colorado, the United States Supreme Court held that Rule 606 promotes full and vigorous discussion by the jurors while deliberating because it provides jurors with considerable assurance that after being discharged, they will not be summoned to recount their deliberations and they will not be otherwise harassed or annoyed by litigants seeking to challenge the verdict. Rule 606 gives stability and finality to verdicts. And the Supreme Court of the United States in 2017 was relying on their own opinion in the Tanner case, Tanner. And the Supreme Court echoed the concerns that if attorneys could use juror testimony to attack verdicts, jurors would be harassed and beset by defeated parties, thus destroying all frankness and freedom of discussion and conference in deliberations in the jury room. The Supreme Court of the United States was concerned, moreover, that attempts to impeach a verdict would disrupt the finality of the process and undermine both jurors' willingness to return an unpopular verdict and the community's trust in the system that relies on the decisions of lay people who are our jurors. The United States Supreme Court did actually go on to determine and elucidate that there are existing significant safeguards for a defendant's right to an impartial and competent jury beyond any sort of post-trial juror testimony. They noted that at the outset of the trial process, there's voir dire, which provides an opportunity for the court and counsel to examine the members for their impartiality and any biases. As the court is aware, jury selection in this case was longer than the state presentation of the evidence and the defendant's presentation of their evidence. We did a thorough job with voir dire, doing individual sequestered voir dire, and that is one of the safeguards. The Supreme Court of the United States noticed that as the trial proceeds, the court, counsel, and court personnel also have an opportunity to learn of any juror misconduct. That is because bailiffs are available, and they are allowed to note if they witness any juror misconduct. And before the verdict, jurors themselves can report misconduct to the court. And as this court is well aware, this court instructed the jurors, both in the morning and every evening, that they were not to discuss this case with anyone, not even amongst themselves, and they were to report back to this court via the bailiffs or the sheriff's department any irregularity, any outside influences, anyone who attempted to approach them, and this court vigorously instructed them on this. The Supreme Court of the United States held that these procedures do not undermine the stability of a verdict once rendered, and even after the trial, evidence of misconduct other than juror testimony can be used to attempt to impeach the verdict. I want to note here other than juror testimony. Extrinsic evidence must be what is presented. I provided the court and defense counsel with 2 cases from the 11th Circuit, United States versus Cuthel, C-U-T-H-E-L. And that went over the court's duty to investigate. And that only arises when the party alleging misconduct makes an adequate showing of extrinsic influence to overcome the presumption of jury impartiality. Actually quoting to United States versus Sun Mun Yoon, and that's that 1983 case where they were accused of tax evasion, that a trial court is required to hold a post-trial hearing only when reasonable grounds for investigation exist, when there is clear, strong, substantial, and incontrovertible evidence. And the state's position is that we do not have that here. In other words, a specific non-speculative impropriety has occurred which could have prejudiced the trial of the defendants. That is what they're required to show, non-speculative impropriety. A hearing is not held to afford a convicted defendant the opportunity to conduct a fishing expedition. That is right from the United States Supreme Court in the 1983 decision. Of course, relying on our Rule 606, the defense attorneys did provide this court and myself with the transcripts of the 3 jurors' statements. Everything within those statements, they do not rise to the level that the Supreme Court of the United States requires and the 11th Circuit requires, which is specificity from an external source other than going back and interviewing jurors 6 or 7 months after they have rendered a verdict. And with 606, we have 3 prongs. One does not apply here, and that is filling out the verdict form incorrectly. We have the first prong, which is when a juror seeks out extraneous prejudicial information. As you'll recall from one of the cases, they had a juror, it was a habeas case out of our Supreme Court here in Georgia, who actually did a test drive to go ahead and determine whether the defendant could have made it to the crime scene on time. Of course, that is a juror seeking extraneous prejudicial information. The other example, which is the Part B under 606, the second prong, is if a juror has someone who tries to bribe them or tries to threaten them. It's an external pressure on that juror, not something made up in the juror's head. Okay, and I would analogize that to defendants who are being questioned by the police who think, well, I thought they were threatening me or I thought there was hope of benefit, but it was all made up in their head. The police did absolutely nothing to encourage that. In this particular instance, there's absolutely nothing where there has been shown that external influences were brought to bear inappropriately on any of these jurors. So the state's position is that we're objecting under Rule 606 and under the cases I've cited because nothing that they have provided to us so far from the jurors' own words rise to this level. And there's been absolutely nothing provided to the state that they're going to provide extraneous testimony through a witness or documents or anything else that these jurors were inappropriately influenced or pursued extraneous information or that extraneous information was given to them. Thank you, Judge.
Yes, Your Honor. I know first, with respect to the, Ms. Duncan does not take any decision in Harris versus State, 2023 decision. I thought I had it right there. I'll bring it later to the court's attention, but in which, among other things, the Supreme Court of Georgia noted that there are differences in the application of Rule 606 as applied to state courts, or state application of it as applied to the federal application of it. In fact, jurors are from time to time subpoenaed to testify regarding exceptions under the rule. That rule, as stated in Official Code of Georgia, Section 24-606B. There is a prohibition in the first part of that, which is absolutely a prohibition against attempting to impeach a verdict, which the court has received from us a notice of our intent that included exhibits from the recorded interviews of the 3 jurors who did speak with us. And note, it's a bit of an overstatement to say all 12 of them or 9 of them refused to talk to us. A few did, and some were just not available. We couldn't find them. But 3 did talk with us. And we submit, and we have submitted to the court, which in a somewhat awkward situation where our understanding was that some things that we submitted to the court were not to be filed with the clerk of court. And well,
You can make how you want.
well, I wanted to read the court's order, Your Honor.
Most people. No time for these proceedings. The history of this proceeding was very clear. This court never instructed anyone not to file something or do anything that would require a sealing or other action by the court. I understand that notice may have been misread. That's not a concern of the court. I understand the state was served with everything, the court received everything, so I don't intend to debate it. But I just want to make sure that we're clear on the record that this court has never instructed anyone not to file something.
If I might address the court with respect to the language of the court's order.
You don't need to. I'm telling you, the order was never intended to tell anyone not to file something.
Well, we have submitted to the judge, to Your Honor, and to opposing counsel and to co-counsel all of the material that we're addressing. We prepared and submitted to all parties the notice of intent to present juror testimony. Attached to that notice were exhibits that described, in part, the testimony. I'll call it a pre-proffer. We wanted to alert the court and alert counsel what it is that we are, what it is that we are attempting to present to the court. I misread perhaps the court's order as saying that file it with the clerk, which what I did was file the notice without the exhibits, and I'll cure that today by filing the exhibits with the put them on the record. And I understood it to be a matter of this court's concern over the anonymity and privacy of these jurors. The court went to great lengths to preserve their anonymity and to preserve their privacy. And it is very important that they be protected in that way because it's a high-profile case. There were demonstrators. There were reasons to protect their anonymity. We read the court's order as saying that. And, in fact, I addressed the court in correspondence asking for direction on that. I addressed the court in May. I addressed the court in September twice. And within our notice, asking the court to direct us as to how do we go about preserving the anonymity of the jurors. Seems to me that it was a very important factor to this court, and we did not want to run afoul of the court's order. Had we filed the exhibits, then we would have been disclosing the identity of the jurors, and that's the reason we sought direction. Let me get some water. I had an accident, Your Honor, in September that for the time being limits my mobility. So I'm having to use a walker and a cane. And I get very dry mouth. Addressing Ms. Donikowski's argument, State v. Harris notes, and that's the 2022 iteration, and then again in 2023, our Supreme Court has held that the application of 606 is different under the state rule as opposed to the federal rule. Ms. Donikowski has cited to the court 2 federal cases. Even then, the rule, second part of the rule, after we go through the first sentence or the first clause, prohibits juror testimony that would be what is generally known as impeaching the verdict. We're not attempting to impeach the verdict. The second part of the rule provides a juror may testify on the question of whether extraneous prejudicial information was improperly brought to the juror's attention, whether any outside influence was improperly brought to bear on any juror, and then the third one has to do with the verdict having been improperly filled out. We're not addressing that third one. In our proffer, I submit that the juror testimony that we have offered in connection with our notice to the court is exactly what is permitted under the rule, and that is whether extraneous prejudicial information was improperly brought to the juror's attention and whether any outside influence was improperly brought to bear on any juror. I don't know, even today as I stand before Your Honor, how far to go with the gallery here, how far to go in discussing that before the court without going into the specifics of individual jurors and without going into their identity. And I still seek direction on that. We're prepared to go in any manner that the court directs, but I don't know what the court directs on it. I've been doing this for over 50 years. I've had a few motions for new trial. I've had jurors testify, but I've never had a situation where I needed to preserve the anonymity of jurors, and that's where I need some direction. That's the position, is that what we have submitted to the court, what the court has before it, what the clerk does not have before it, is material that we submit fits the exceptions under 606. Now, am I at liberty to discuss that exception now, to talk about what these jurors said, or does the court want to continue to preserve some sort of anonymity?
We don't have to get into the names of the jurors. There are jurors identified by
All right, then I'm sorry.
There has to be a proper before you make a rule. So I think everybody is generally in the same zip code here with 606. But when well, and my understanding there may be a second issue out there, which I guess really brought up at this point, having to do with answers that are more dire.
That's correct, Your Honor.
But there has to be some, I need to know what it is that specifically under Rule 606, that we're considering Rule 606, that the defense intends to present that would be relevant and material to the motion for new trial.
If I might refer to the notice that we gave to the court for a moment. I am prone to falling and can't get up when I do. This is from the notice that we presented to the court. The notice was filed without the exhibits on October 7th of this month, October of this month. I had in earlier filings with, not with the court, but in exchanges with the state, had certainly not withheld this information. The state would have known what we were doing. The attachment, the first is in Exhibit A, which is the affidavit by the investigator who conducted the interviews. And there were several issues involved in these discussions. And we'll just go by number in sequence. Juror number 79. At page 8 of that interview, recorded, and the court has the transcript. When I say the court, I need to distinguish between Your Honor and the court in some way. The clerk of court does not have this.
Is this all under this notice of intent to present evidence from jurors?
Yes, Your Honor. That was submitted to the judge and to the parties. Not to now. The covering notice was sent to the clerk and has been filed, but we did not, and we specifically noted that we were not attaching the exhibits to the notice as filed.
So let me, and maybe this will shorten this up. So the proffer that you intend to make would be these jurors' statements. So liberally are limited to juror statements contained in this notice of intent?
No, Your Honor. It's broader than that. This was just an excerpts from those recorded interviews that we believe fit the exceptions under 606. And with the entire interviews, one is 80-some pages. That's for Juror 580, Juror 380, and Juror 79 are shorter. I think one is 41 pages and the other is 50-some odd pages. But we have those here in a form that we mark them as exhibits, the entire interview, and intend to proffer them to the court, at least to make a proper record as to what the substance of that was. What you had in the way of exhibits to the notice was excerpts which we felt illustrated that the jurors, and of course it's hearsay as long as we don't have these people here to testify. And that's the reason we subpoenaed them. What we have is what the affidavit from the investigator is not offered for the proof, to prove the truth of what these jurors said to him, is offered and not as hearsay, because it is simply testimony or an affidavit to the effect that this is what the jurors told him, not that this is true. Now, in order to deal with the truth of it, we would have to have the jurors here to testify. And that's why we subpoenaed them.
I'm just trying to figure out what we need to work through, because there's a legal issue under Rule 606.
Yes, Your Honor.
Let's stick to the, I want to do this. Mr. Chapman, Mr. Zeller, are you going to be adding anything on the legal side of this, or are we really getting into the problem?
No, Your Honor, nothing on the legal side.
No, I think we all agree with the law. Is the question is whether or not the proffer is the standard. I think that's it. And it's just whether or not the counsel is going to
So let me set the stage then for whatever this proffer is going to be. So I did look at the notice of intent as
yes,
well
Your Honor.
as the excerpts from these jurors. And let me, I guess I'll try to present the guardrails that I see and then see where this proffer goes. There's two issues as I understand it. One is there was a juror who apparently appeared at the courthouse on the weekend. Well, really, there's 3 things raised. Yeah, the juror who appeared on the weekend, this one issue. Question of whether or not a juror held a bias that was undiscovered in voir dire. And then finally, there are a number of statements in here from a couple of these jurors about what they thought of the charge. Okay.
Yes, Your Honor, that much is submitted because part of our motion is that we contend that the court erroneously charged the juror with respect to the law of citizen's arrest. And that's something that I assume that you and I will continue to disagree about, and which is what we do, lawyers and judges.
Sometimes.
Well, I've had, one of the things I wanted to do, and the sheriff said I had to get your permission, is I wanted to record this proceedings because I've been at it a very long time and I've had one motion for new trial granted. Judges like to say if there's an issue, they'd like it to go up because if you grant the motion, there may be some finality. And I fully understand that this court, at least statistically, the odds are that this motion will not be granted. But my job then is to create a record that we can appeal on. And that's an appropriate approach for a judge, because if you were to reverse your various rulings in the court, then we'd have some chaos as to where we are, and we'd be granting a new trial, and the Supreme Court needs to pass on these. And I understand that I'd be surprised if that is not the court's attitude. And the reason I wanted to record these proceedings is because I hope to continue to represent Travis McMichael in an appeal to the Supreme Court. And I wanted to record and create my own transcript and get ahead of the game so that I can begin working on that. That request is before the court. I did not bring the recording information here today because my assistant, who would be here and will be here, is not available this morning. So that's just asking the court. That's kind of off topic. The proffer, and I'd call it a pre-proffer, is with this notice of intent, is to submit to the court, this is what we hope to proffer to the court. And it just is excerpts from the transcripts. And the transcripts have not been authenticated beyond this affidavit. And as Ms. Donikowski has correctly noted, that this is hearsay. Has not correctly. She has said it's hearsay, and it would be hearsay if we were submitting it under Rule 801 to prove that these jurors told us the truth. It's just an affidavit to establish not that it's truthful, but that this is what the jurors told us. And then they would have to come and verify or deny that they said these things. And that's when the actual evidence would be. What I brought is transcripts, the full transcripts, marked as exhibits, which I certainly don't want to read to the court. There's hundreds of pages, but Mr. Wilson, the investigator, has compared them to his audio tapes and will testify that they are correct and accurate statements of what was in the audio tape. Now, one of the jurors said, well, I was just going to
get back to where
sure.
I was. So we've got these 3 issues. First, let me address the easy one first. As to any juror statements about the jury charge, that's not coming. whatever the jury thought of the jury charge, their impressions of the jury charge, all of that gets directly into the deliberations of the panel, which is clearly not permitted under Rule 606. So that is not coming.
We respectfully disagree and understand that the court overrules any objection we have on that. Our position on that is not what they deliberated, is how they interpreted the written charge. And one of the jurors even talked about on the rule of pertaining to citizens' arrest, that we applied the new law and not the old law. Well, there is no new law. The old law was just repealed, and we had to do it according to the letter of the law. So that we.
The issue that goes directly into jury deliberation, because they would not have received a written charge until they were in deliberations.
That's correct.
Which then just further confirms to the court that concerns the deliberations of the panel. The next issue.
Well, respectfully, when we tender the recorded interviews, we will tender the entire interview and respectfully submit that it is appropriate and not fault.
You can create your record, that's fine.
That's all I'm doing here, Your Honor, and I think I've indicated that's all I expect to accomplish today.
The second issue is the juror that was alleged to have appeared at the courthouse during the weekend. I think Rule 606 makes very clear that it would be permissible to determine whether or not that juror was provided any extraneous information. But that's where the inquiry stops. Other than whether that extraneous information, I guess, was actually provided to any other juror. What the impact of that extraneous information was, if it existed, and how it was addressed by the panel individually, I mean subjective, is not an area that we're going to get into. The argument then, from the court's perspective, is if there was any extraneous information, whether objectively that could have had any impact upon the panel, if in fact it was shared. And that's going to be the limitation on the court's rule.
Again, Your Honor, I understand the court's ruling. We respectfully disagree. The testimony that we're addressing in that particular instance is that this juror, during the demonstrations, after the court had instructed the jury to stay away from interaction or hearing or talking with you, he went, there was apparently a hot dog stand or food trucks or vendors out on the grounds around the courthouse. And he came down, his transcript says he came down, purchased a hot dog, and listened to people who were making speeches of the nature that I suspect was justice for Ahmaud. But he described what they said was, in his words, blah, blah, blah. I mean, he didn't go into detail about it, but he was listening to people making speeches at the rally for Ahmaud. We can only assume that he was not hearing things that he was hearing things that he should not have been hearing, and that is an extraneous injection into his deliberation. The law is not, and I'm familiar with the cases the court's relying on pertaining to whether he shared it with others. But there's a presumption, and this is one of the places we disagree, or the Georgia Rule Supreme Court has a different interpretation as to Rule 606 as opposed to the federal courts. If we show this is inappropriate, it's misconduct, and there is then a presumption of bias or prejudice or against, well, actually against the state. The state then has to prove beyond a reasonable doubt, not by preponderance tests, to show beyond a reasonable doubt that it did not impact it did not impact this juror. That's the difference between the federal and the state application is 606, and that's in the Harris case. And then there's an additional argument with regard to that juror having to do with his responses in voir dire, and that's not the issue right now we're talking about, but I can bring it up.
Okay. It's the third issue that I was about to address.
All right,
It's
Charlie.
indicated where I am on the first two issues. As to the question of his answers, there are some questions and answers in this notice of intent, affidavit, however you want to describe it, indicating his personal position about certain things. The issue for the court is, as I understand it, whether there was a material falsehood that he presented a material falsehood during jury selection with regard to any bias, and whether or not that material falsehood resulted in prejudice. That is what we're going to limit any inquiry to, whether or not there was a material falsehood during jury selection. Now that's, I will just candidly say, you're going to have to get into a very, I assume this has been done, and he gave extensive answers during jury selection, which are in the transcript. So the issue isn't so much what he said, but whether or not what he said, as compared to what was going on during jury selection, indicates to the court that there was some material falsehood.
Respectfully, in the court, the state has honed in on his truthfulness in individual sequestered voir dire. Our issue is, or our point is, that it was false when he answered, along with all of the people on the panel, the general voir dire questions, not the individual voir dire questions, when he said there was no bias or prejudice resting on his mind. And that's where we address his falsehood. Because of the things, let me get the language. And in our amended motion, I addressed it at page 12, Juror 380 concealed his bias in favor of the Arbery family. And of course, to even get to individual sequestered voir dire, you have to pass the general voir dire, in which you declare that you have no bias resting on your mind. And I might read some of this to the court. My investigator asked, what were your thoughts? This is from the transcript, which I understand has not been authenticated or presented to the jury, but this is what we expect the transcript and the recording, and we have the recording, would say. What were your thoughts when you were selected as a juror? To tell the truth, I felt sorry for the family, so I said, Lord, I feel sorry for the family. You want me to help them, then I don't mind helping. Don't mind doing it. Like that, just as I was talking to you. But when you say, this is the question, you felt sorry for the family, did someone talk to you about sitting on the jury? No, nobody. Thank you, sir. I appreciate it. I'll go back. When you say you felt sorry for the family, did someone talk to you about sitting on the jury? No, nobody. I didn't understand what you mean, felt sorry for the family, the investigator's question. And the answer was, I felt sorry for the family and everything. That was even before I see the tape, the film and everything. So I talked with the Lord, and this is a very religious man. I sat on his porch last week and talked with him. He's very faith-driven. So I talked with the Lord on the way, going to work. I said, if it's up for me to do this, then I'll do it to help the family. Justice got to be done. Then on the next page, when you say the family, you're talking about Mr. Arbery's family as far as what all they had gone through. Yeah. How much, if any, influence did all these high-profile people coming to this trial and obviously sitting in support of Mr. Arbery's mother, how much did that play in how you thought about the case? Because you acknowledged you felt sorry for the family, and who wouldn't? They lost their son. And Mr. 380 says, yeah. And then the question is, did that have an impact on you? Answer. Not really. At first, I feel, like I said, at first I felt, when I found out, this next sentence is one that kind of gives away who he is, but I'll go ahead and read it. When I found out I was the only black, I was like, oh my God, now I'm laying in bed, can't sleep anymore because I felt like the weight of the whole black race was on my shoulder. And I started praying. And the Lord said to me, He said, all you got to do is just what I tell you to do. And I'll coach you through the whole thing. He said, you've got to talk with everybody. You can't be quiet because they'll think you're mad. Because, and then he says, I never did get mad. I got a little angry when I saw the tape. And then further down. So the Lord, He set everything up. Anyway, after I cried for the family, and it turned to a joy cry, and didn't even know I had been picked for the jury yet. When He did not make these feelings known in response to the general voir dire question, have you formed and expressed any people?
So now we're making arguments. So what I was simply saying is the issue before the court is that you are alleging that there were material misrepresentations made in voir dire.
Yes, Your Honor, it's a material misrepresentation in the form of not acknowledging his, because it's a general voir dire question posed to the entire panel.
And let me remind everybody, because I know some folks did not participate in voir dire, that voir dire there was a two-step process to voir dire. There were general questions that were agreed to by all counsel, and then based upon the general questions, each party was then given the opportunity to indicate to the court whether they wished to have the juror come to individual voir dire. Juror 380, who we're talking about, went through individual voir dire, which was then a process that allowed clarification by all lawyers, because all parties then would have an opportunity to ask that juror questions. And so that's why I have indicated a couple of times now what I would expect if we go down this road with any of the jurors is that there is reference to that juror's answers to voir dire. Because whatever he has said now is all well and good, but that's not what we're looking at. The issue before the court is whether there was a material misrepresentation during voir dire, and ultimately that prejudiced the defendants. And so the ruling of the court is, we're not just going to get into these statements. There has to be some reference for the court to statements or positions, opinions, because all of these different things were presented during the voir dire process. Because my understanding is these statements were provided, it was months, 6 months, 8 months, 9 months?
No, Your Honor, the recording, the interview was roughly 6 months after the trial. The focus of this is what was this juror's attitude and bias when he did not, when he was asked, along with the rest of the panel, when he was asked if he had any prejudice or bias resting on his mind. Now,
I've indicated what the court is. There needs to be a record, because there is an extensive transcript on Juror 380.
yes, Your Honor.
The general voir dire was followed up on by all the parties. So I looked through it, not in the detail that I'm going to ultimately have to, but I know based on my preliminary review of Juror 380, and that there were questions. Let's see, Mr. Rubin, on behalf of your client, did the individualized voir dire. He was asked about his opinions, whether he could put any of them, receive some pretty straightforward opinions. Specifically asked by Mr. Rubin, again, representing Travis McMichael at the time, whether or not he could put any of those issues aside and listen. So again, the court is going to need more than simply statements made 6 months after the verdict. The issue before the court is whether there were material misrepresentations made during voir dire.
And we respectfully submit that this portion of his transcript reflects that he got on the jury so that he could help the Arbery family. That and maybe stated too strongly in my motion, but we look at him as he was there to assure that there was no acquittal in this case. That's why he was there. That's what the Lord directed him to do. Now, I sense the court's ruling.
Well, you don't need to sense it. I have provided it.
All right. Well, that said, we still stand on our position and take the position that this evidence, when it becomes evidence rather than a transcript which would now be hearsay, but once he testifies, it shows that he got on the jury by not disclosing that he had a bias in favor of the victim's family. And that, it guided him. It guided him so much that the Lord told him what to do. And we'll stand on our position. I secure the court's ruling, and I certainly understand the court can make a ruling. The question now for me is, what may I proffer to the court? And if the court, I would at least submit that our notice of intent to present jury testimony is an adequate proffer of that issue. We have to submit the exhibits to the affidavit, which we didn't because we were protecting juror anonymity. At the same time, I submit it's an issue that needs to be decided in Atlanta, and that's why we want to create a record here.
I understand, Rick. Anything then from Greg McMichael? No. From Mr. Pratt?
Are you asking on everything that?
What we've addressed, well, let me ask you to be more specific, because I was going to go around the room to make sure everybody understood what the court's position was in ruling on the three matters that we've now discussed with regard to these jurors being called and what the court will allow for testimony. Any questions about that?
I did want clarification on position number 2. You allow for testimony on, I guess, the outside influence or the extraneous information, but not how it affected his deliberation.
Not how it affected his deliberations. That's an objective inquiry for the court.
Right.
So objective inquiry for the courts, and objective, I guess the argument would be, from the defense perspective, an objective argument on how that influenced or could influence the panel to the point where it could be impactful given the standard of the courts having that done.
So will we be able to show the type of influence that was around the court that day, or that during the trial?
The court's ruling is this juror is being called because it's my understanding that there's belief that he received information extraneous to the court, right, from outside the court. I don't know that he did. Based on what I've seen in the affidavits, I'm not sure specifically what that is, but I'm going to permit inquiry into whether or not there was anything extraneous there. Then we'll also with whether he mentioned it to anybody else. But as far as whether he considered, or how he considered that during deliberation, or what he thinks any impact of it would have been on deliberation, we're not going to get into it.
Just one follow-up, if I may. Also, with regard to 606, it says whether any outside influence was improperly brought to bear upon any juror. So would he be able to talk about the outside influence that he witnessed, or
That gets into deliberation.
okay?
I'm sorry, I didn't mean to interrupt.
Hold on a second. I think it's very clear on what was going on. I believe Mr. Goff, on behalf of Mr. Bryan, has made a very clear record as to what was going on around the courthouse during the trial of this case.
I was going to make, I have a list, right, so I don't need to do a correction on that. And I agree that it's not, the law is clear that jurors can't say how it impacted the deliberation. The law is clear that it's objective. On the last issue, I think we talked about juror 380 and the misstatements on Georgia. Is that correct? I will just add one thing that I do have in my notes, and this was when I read the transcript on page 2156. There was a notation from Ms. Chazal that the juror had nodded at the victim's family. The juror nodded at the victim's family after he was walking out. So that was something that was raised during, and that was volume 9, part 1. That was the notes I had. His individual started on page 2100, and as he's walking out on 2156 is when Mr. House said, in my notes, this is what I wrote down. He says that the juror nodded to the victim's family as he walked out, and but he didn't ask for it. And later on, when the court asked for structured calls, and he was not, there was no motion to structure calls. So I just wanted to point that out.
During Fort RSL.
Yes.
At the end of individual and Fort RSL. Yeah, I can't remember whether there was a motion for calls. So
There was not a motion for calls on 38. There was not. That was in the very next, that was volume 9, part 2, motion for calls for those that can.
From the state, any question about the
No, Your Honor.
Two points. One, I worked very closely with Mr. Chappell, representing Greg McMichael. I represent Travis. My understanding is he adopts in full what we've argued here and what we presented in the motion.
Yeah, we'll both on the amended motion.
And the argument I've made here today. Your Honor, I have heard and will certainly abide by the court's rulings. I must admit I'm not 100% certain where you are limiting me in terms of presentation.
I don't think I could be any more.
Well, am I going to be permitted to have my investigator come testify regarding the accuracy of these transcripts? I'm not going to ask the court to look at the transcripts or read the transcripts. There are hundreds of pages, but he has authenticated.
I can't tell you how to present your case.
I'm not asking. I just want to know, am I limited there?
So what objection do you have? I don't know what your case is going to be. There are 3 specific issues of law that I have presented.
I understand.
However, the defense then wishes to present the motion for a new trial. Given those rulings, we are here to address today.
And I want to make an inquiry with regard to such things as the motion or the notice of intent to present juror testimony, which we filed with the clerk without the exhibits because we were trying to protect juror anonymity. I would be permitted, I assume, to file that with the exhibits attached after this hearing.
So, I have not been asked to seal those.
I'm sorry?
I have not been asked to seal that at any point.
Well,
Because of that, at this point, the court can't sua sponte seal. The court has tried very hard during these proceedings to ensure the anonymity of the panel for a variety of reasons that I will need to get back into. And that has been respected throughout. If, and I would suggest this may be one of those cases, there is something that is being submitted to the court that any one of the parties believes may create an issue, then for these jurors, then that needs to be submitted to me with a motion to seal it. I need to hear from the parties, but then I need to have a hearing under the rule to ensure that the public interest is not outweighed, or that the public interest is outweighed, I should say. And then I'll seal them. But it's not the court's duty to just seal records.
I fully understand that, Your Honor, and frankly, from the defendant's standpoint, from Travis McMichael's standpoint, it doesn't matter to us whether it's sealed, but given what the court has just said, we move to file the entire motion with exhibits under seal.
So the motion
It was filed, Your Honor, with the court. The notice of intent that was filed, let me get the stamp. The stamp we have from the clerk's office is that the covering motion, not the exhibits, were submitted and filed with the clerk of court on October 7, 2024 at 4:28 in the afternoon. We would move to allow us to submit now the exhibits under seal, given the court's observations.
Well, we're going to have to address that. Perhaps I need to give everybody an opportunity to consider that as well as the
I want to make it clear from our position, we don't care whether it's under seal. I'm trying to abide by the court's concerns.
What we're going to do for the time being is the notice of intent will be in the record. We'll hold off on the attachments until the court's had an opportunity to consider the motion to seal.
Thank you, Your Honor. I believe that's all we have preliminarily. I will present at the appropriate time, and Mr. Lamar, who practices law with me, will present the testimony from Mr. Wilson regarding other subject matters. I'm just here to address the proffer. I will call Mr. Wilson for the proffer, and then he will, when we get back to the other issues, then Mr. Lamar will take my position.
Call Mr. for the proffer.
I'm very concerned under the rules what is necessary to authenticate. This is not a situation I've faced in 52 years with all of the anonymity. And so I'm concerned that I don't run afoul of any rule of this court and yet follow what I understand to be the law. And I believe, my understanding of the law is that we need to proffer these affidavits as exhibits, and I'm sure that we'll proffer them under seal as well, because they're extensive and probably, according to the court's observations, they do not need to be available for public review.
The court's already ruled on this. That's the reason I asked the question about the notice of intent and the jurors who were listed and the statements that were made. And what I was told was that is effectively a summary of what these statements were. The most material statements being part of the affidavit. So I understand what the proffer is at this point on those specific jurors. And just to be clear for the record,
Jurors 79, 380, and 580.
yes. So, you have addressed what you believe those individuals would be testifying to, and I have ruled. I have not ruled that those individuals cannot be called. I have indicated what the court's position is and what the limitations of their testimony will be.
I understand, Your Honor. Because sometimes I'm a little slow on the uptake, I think I understand the court's rulings. If I come close to violating them, it's not intentional. That's where I am. And also, we view the notice of intent, I called it a pre-proffer, just to give the court an understanding of why we believe that this testimony does not violate 606. So,
it sufficiently apprises the court as to the issues. I've ruled on the three issues that I see are raised by the defendant's proposal to call these witnesses. In the context of the court's rules, let's go ahead and move on to the motion for new trial.
all right, then I believe Mr. Bryan is going to go first with regard to the substantive portion, and then we'll follow.
Mr. Zell.
Thank you, sir.
All right. There's been some discussion during our brief status on about the order of the presentation. It's my understanding that Mr. Zell has volunteered to go ahead and move forward on the motion on behalf of Mr. Bryan. First, I do have filing the motion, amended motion for new trial was filed on May 22nd of 2024. The state has had an opportunity to file a written response. I received my email, so it was filed.
Yes, Your Honor.
So the matter is before the court. Mr. Zell.
Thank you, Your Honor, and yeah, I'll do whatever anybody wants me to, go first, last, in the middle, somewhere. I filed my motion, Judge. My intent was just to present the issues that I thought needed evidentiary support that were required to be presented before appeal. I do not intend to relitigate issues already raised at the trial or pretrial, which just leaves the two issues of ineffective assistance of counsel.
So I'm saying you're preserving everything in the motion.
I think everything was adequately preserved, all the other motions. I'm not going to ask. I know Ms. Dunikowski's brief got into many other issues that maybe were raised in the original motion filed by Mr. Gall, but I'm just focusing on these two, and Mr. Gall's here, and I would just, if one of the bailiffs could sound for Mr. Henry, he's out in one of the witness rooms, unless Your Honor wants me to go get him.
No, that's fine. If we could go ahead and Mr. Kevin Gall.
Call. I just call him Kevin, so I never got his last name. right, if you could state your name,
Kevin Goff,
and what is your occupation?
I'm an attorney.
And are you licensed in the state of Georgia?
I am
How long have you been licensed?
since June 1987.
And do you generally practice criminal law?
Yes.
Briefly, can you just give us some of your experience as a lawyer?
I worked for a federal judge in Montgomery, Alabama. Served as law clerk for a year there. Private practice for a year. I came here to be an assistant district attorney in 1989. Assistant district attorney till June of 93. I went into private practice at that time. I remained in private practice until August of 2012, when I became circuit public defender for the Brunswick Judicial Circuit. I held that position until April or May of 2016, and went back into private practice, and I've been there since.
Is that, and at some point you came to represent Mr. Bryan?
Yes,
Okay. And were you in private practice at the time?
I was.
Were you appointed, were you retained?
I was retained.
Now, I don't think it's a secret here that you knew that Mr. Bryan was subject to some criminal action or suspected criminal action in this county before you were hired?
Yes, I was originally hired for pre-arrest representation.
Do you recall when you first spoke with Mr. Bryan?
I don't. It would have been probably in April or early May, but I can't be any more specific than that.
Okay, so Mr. Arbery's death was February 23rd, 2020, and so sometime, a couple of months later, we have a time span of middle of April to 1st of May.
The McMichaels were arrested, and I think at that point in time, the urgency of Mr. Bryan's situation became clear.
Now, do you recall the date the McMichaels were arrested?
I don't recall the exact date. I believe it was in early May.
Does May 7th sound accurate to you, or could that be consistent with what you recall?
That fits the time frame.
And we went over some of these timelines to kind of refresh your memory, so do you recall when you actually formally entered into any kind of agreement with Mr. Bryan to represent him?
May 8th. There's a check dated that day and a fee agreement dated for that day.
Now, prior to May 8th, did you have any conversations or communications with prosecutors, police officers regarding Mr. Bryan?
I don't think so. Prior to May 8th, my recollection is that either Mr. Bryan or his wife had reached out to me about his situation, and I had encouraged them to seek other counsel. At that time, that didn't work out. But it had to be around, May 8th was the day I was formally retained.
Would it be fair to say that you then talked with Mr. Bryan? I'm not asking you to repeat what he said, but talk with him about what transpired?
Yes, we probably had a brief conversation, maybe over the phone before then, but we really didn't get into the details of it until May 8th.
Okay. And at some point, Mr. Bryan met with Agent Sechrist and made a statement?
Yes. I think if I recall correctly, when Mr. Bryan retained me, the GBI had reached out to him the day before, maybe, or the day before that, or maybe earlier in the week. They had reached out to him and they wanted to interview him. And he came to me because they were expecting an answer. And I think we put off the GDI. I think it was Agent Secrets, but we put the GDI off at least over the weekend, trying to get a better idea of what was going on.
So May 8th, you begin your representation. The first interview is on May 11th. Is that?
I believe that's right.
So between May 8th and May 11th, did you have any conversations with any prosecutors, district attorneys, or police officers regarding Mr. Bryan's case?
It's difficult for me to recall that now. I can't really refresh my memory from that time frame. So it makes it hard for me to answer that. But I know that we would have talked and got what information we could. A lot of the information that was available was frankly through the media. Information leaked or appeared to have been leaked, whether from Glenn County PD, GBI, the Arbery family or their attorneys or whoever. There's no way at this point in time I can speculate on where the information was coming from. But there was information. There was a short snippet from the video that Mr. Bryan had made at the time of the shooting and that turned over. But I'm not sure he retained a copy of it. But there was a snippet of it, or a snippet of the video from the actual shooting that had made it in the media and a few other things. There was a lot of misinformation. I didn't really spend a lot of time looking at the Arbery matter until Mr. Bryan indicated an intention to retain me. I know that sounds weird, but this is my living. I generally don't pay attention to cases that don't involve me. So I didn't have a whole lot of information before Mr. Bryan.
As far as talking to anybody from, whether it was the Brunswick Circuit or the Atlantic Circuit or the Cobb Circuit, you had no conversations between May 8th and May 11th?
With prosecutors?
Yes.
I don't believe so. I think I had made a point of pointing out that I wasn't getting any responses to inquiries. But at that time, from what I can see, technically, Joette Holmes had just gotten appointed or just gotten into the case, and Mr. Durden had exited or was just exiting. The GBI had different reasons why I was having trouble getting in touch with people, and those explanations were plausible at the time. It may also well have been that they just didn't want to communicate.
Prior to May 11th, you attempted, and is it fair to say you attempted to contact somebody from the Cobb County District Attorney's Office but received no reply?
I'm pretty sure I reached out to a prosecutor. I can't recall who.
Okay. Now,
But I do know that I had mentioned to the DBI more than one occasion that I was having difficulty communicating with prosecutors and their concerns.
was it Agent Seacrest that contacted Mr. Bryan, to your knowledge, about doing an interview?
I can't recall whether Agent Seacrest contacted Mr. Bryan or another GBI agent initially contacted Mr. Bryan and let him know that Mr. Seacrest would be wanting an interview. That much I can't recall. But Mr. Seacrest seemed to be the lead agent at that point in time to be dealing with Roddy Bryan. And there was a lot of investigators down here. The GBI had temporarily taken over offices in the DNR complex, for lack of a better word, off to the side of the Sydney Linear Bridge. And there seemed to be a lot of people. But I believe Agent Seacrest was the lead officer with respect to Roddy Bryan.
Did you speak with Agent Seacrest then, prior to May 11th?
I think I did. I'm pretty sure I did. It's possible it was text instead of calls, but I'm pretty sure. Yeah.
Any other agents you recall any specific names of anybody you might have spoken to?
Agent Dial was kind of out there, but I can't specifically recall what his exact role was with respect to Mr. Bryan in this time frame. But there were a bunch of DBI agents floating around.
Okay. From May 8th to May 11th, whatever time the interview started, did you speak to anybody in the Glenn County, the responding police department's office about anything they may know about the case?
I can't tell you that I spoke to any particular Glenn County Police Department officer. I made some inquiries around. This is a small town, but I can't recall any specific conversations with specific individuals at this time.
Okay. And it seems that the freshest thing in your memory is Agent Seacrest. So with Agent Seacrest, did he give you any information about anything he uncovered in his investigation, or the police department or GBI's investigation to that point in time prior to the May 11th interview?
I don't recall Agent Seacrest sharing a lot of information. That's generally not how this works. They generally try to give out as little information as they can while getting as much as they can. They did have to share some details because they couldn't really ask Roddy questions without sharing it. I mean, they had to inform him of some things so they could inquire, but they didn't share a whole lot. I do remember being told, don't believe what you read in the papers, things like that.
Had you received any, back it up, were you aware that Mr. Bryan had made statements to the Glenn County Police Department prior to May 11th?
Yes,
Were you aware those statements were recorded?
yes.
Had you seen those or heard those prior to May 11th?
I believe that small snippets of the body cams may have been in the media by that time, or information from them had been put out there in the media from whoever. But I don't recall any specifics, but I know there was a lot of information that the vast majority of those interviews that I did not have access to.
Would you rely on any media reports in representing Mr. Bryan or any other client you may represent?
Depending on the circumstances, I'll utilize any resource that's available if I feel like I can rely on it.
Would the best evidence of what Mr. Bryan said be the actual interview or a media report of what they have garnered from some leak?
The absolute best information as to what Mr. Bryan said to law enforcement, the best information would be the body cam videos themselves from the officers. And there were multiple officers on the scene the day of the shooting, and some of their cams picked up more of the conversation, some of those picked up less of the conversation. I also had the benefit of Mr. Bryan as my client to recount as best he could what was said. Now, people tend to recall things the way they want them to be. And in retrospect, maybe his initial explanation of what was said was a little more favorable to him, slightly more favorable than the actual videos turned out to be, but all in all, it wasn't a day and night difference. I mean, he legitimately tried to the best of his ability to tell me what had gone on that day.
Would that be unusual that what a defendant tells you is not actually what is reported during a statement?
Clients lie to lawyers all the time in the initial stages of the case, but in this case, for the most part, I thought Mr. Bryan was very truthful. I thought he was, to this day, I can't say that I ever caught Mr. Bryan in a lie of any kind. I mean, he may have embellished or understated things, but generally speaking, we had a very good relationship, and I never had problems with him like I did with some clients where I walked in the courtroom and get blindsided.
In addition, not just lying, but maybe memory issues or perceptions or stress of the event, or those other factors that weigh in on whether or not Mr. Bryan or any other of your clients are able to recount exactly what they have informed the police?
Yes, clients under stress are often less reliable reporters of events. And Mr. Bryan was under extreme stress, and he is an individual I could certainly say today, if I couldn't say in May of that year, certainly someone who doesn't respond especially well to stress. That was certainly a factor that entered into decisions made later in the case, as to, for example, whether he would testify.
In addition to the body cam on the scene, did he not also go to the Glenn County Police Department and make a formal statement as well before your representation began?
I think he might have made 2 statements.
So now going to this May 11th interview, Do you recall any conversations you had with Agent Seacrest about the parameters of this interview?
Yes. As I explained, well, I mean, I was trying to buy time, among other things. I wanted to get a polygraph examination for Roddy. And I wanted to be able to do what I could for Roddy, and the more time I had, the better off I was. On the other hand, it seemed pretty clear, having already arrested the McMichaels, that the GPI would have probable cause to arrest Mr. Bryan if they chose to do so. He was subject to being arrested at any moment. So pushing back the cooperation with the GPI beyond a certain point was simply going to trigger his arrest. So that was a balancing act. Because once Mr. Bryan was arrested, it's difficult to unring that bell with the entire world watching what you're doing. Once the GPI made the charging decision and arrested Mr. Bryan, that was kind of, in many ways, an irrevocable decision. There was no coming back from that. So I didn't want them rushing to do that either.
Prior to the May 11th interview, were you aware of what, I guess, subsequently came out at trial, or you probably weren't through discovery? Some of the Glenn County police officers, when they interviewed Mr. Bryan, said that Mr. Bryan recounted that he boxed Mr. Arbery in, things of that nature. Were you aware of that before the May 11th interview?
I don't know if Mr. Bryan used the word boxed in, but he was reasonably candid that some of the things that he said to the GPI probably wouldn't sound good. He's just not a very capable person. I don't know that the full, exact flavor of some of that stuff was fully there. I mean, it was a little worse. Looking at the statements that went, it was somewhat worse than what I had hoped for. But I can't say that Mr. Bryan misled me as to any of that. So I'm not sure if that's helping you. I'm trying.
I just want you to testify as to what happened, what actually transpired. So when Officer Minshew testified during the trial that Mr. Bryan said he blocked and cornered Mr. Arbery during the chase, and then went on to how many times and that's according to Officer Minshew, of course, that Mr. Bryan blocked Mr. Arbery in. Were you aware of that before May 11th?
I can't recall whether what I can say is this. Mr. Bryan did alert me that there were things in the statements he made to the police that he was concerned about that were probably not helpful. Did I have the exact full flavor of it? Not necessarily. But there were real issues with what he had said to the police. Among other things, my recollection is that Greg McMichael was doing his best at the scene of the crime to dictate's not the word for it, direct the officers in their work. And, you know, I always felt that Mr. Bryan, what he said that day was partly in response as much to what Greg McMichael was saying as to what he was actually seeing, doing, and looking at the videos, the body cams from that day. I felt that some of the things Roddy said were probably not exactly right, but he just kind of went along with what was going out there. But the problem is you're stuck with that. When you make a statement to the police, you have to live with it. There's no coming back from it. It's not something you can really argue to a jury.
Would it be fair to say that you did not actually speak to Officer Minshew before May 11th?
I'm pretty sure that I did not talk to any of the Glenn County police officers prior to May 11th.
I'll just ask, that would include ex-Officer Lowry?
I don't recall talking to Officer Lowry.
Now, I've asked you about this blocking and this boxing in. Did you ever advise Mr. Bryan not to use language like that when he submitted to this interview with Agent Seacrest?
I can't recall telling Mr. Bryan what to say. I mean, we always tell our clients to tell the truth, and if you can't tell the truth, then maybe you just shouldn't tell it. As far as word choices, it's possible that I suggested other ways to say the same thing. I can't rule that out. When we did the video with Mr. Bryan on the 13th, I mean, I think I interjected at one point and restarted the video because one of the GBI officers started out saying something that didn't sound like it was going to come across very well in the courtroom. So I can't rule that out, but I wasn't telling Mr. Bryan what to say any more than I was telling the GBI officer what he could or couldn't say. And certainly in suggesting that if I remember, we went back, we drove 10 or 15 feet, and we pulled back in and started over again. It wasn't like I was trying to tell the GBI officers what they could or couldn't do. I didn't have that far.
Now, you testified that Mr. Bryan was concerned about, before this May 11th interview, I think, is what your testimony was, that he was concerned about some of the things he may have stated to the police before your involvement? Is
I
that?
think he was concerned, yeah.
Was that something that was specifically part of that concern, the boxing or boxing in?
Mr. Zell, I'm doing the best.
Okay, that's okay.
I'm doing the best I can. I don't specifically recall whether he was concerned about the boxing in. I know that Mr. Bryan was concerned that his. Are you really sure you want to get into that? I think Mr. Bryan was concerned that some of the statements that he gave to the GBI might, in retrospect, not look so good. You know, whether that's specifically boxing them in, trying to run them off the road, there was language that Mr. Bryan used in his statements to the GBI that day, on the day of the shooting, and on the side of the road, that were not well thought out by Mr. Bryan, and I'm not sure to this day that they were even true. But Mr. Bryan was responding that day to things that were around him and what he was seeing and hearing. He thought that day that he was with the good guys. Okay? He thought he was doing a public service that day. It didn't dawn on Mr. Bryan until well after the fact that he might have actually done something that other people might think was not heroic. I mean, he thought he was the good guy. And I understand why.
Well, in response anyway, Mr. Bryan's statements were, not only were they played for the jury, but the officers testified to them, and I'm speaking about pre-May 11th. Is that correct?
The statements from the day of the shooting?
The day of the shooting and subsequent interview before your involvement?
Yes.
Okay. So they came out, so I'm not asking you to reveal anything that wasn't already made known to the public as far as his interviews.
Okay, but when you're asking me about what he's telling me, he was aware that, in retrospect, that he had created some liability for himself and some of his word choices when he spoke with the GBI. And I think that objectively, when you look back, what was said on the side of the road and what was said to the GBI after the shooting, some of his word choices were poor and made it sound like he had been more aggressive than had in fact been the case. And that really put him in an awkward position. There was no question that the GBI had probable cause if they chose to arrest him. He was subject to being arrested. And if he was arrested at that time, it was pretty clear that he was not going to be released from jail, no matter how many motions for bond would be filed on his behalf. So he had some stark choices to make.
Was there any suggestion, and I shouldn't use that word suggestion, strike that. Was there any advice to avoid using certain language that may have been put Mr. Bryan in this bad light before that May 8th, May 11th or 13th